Hello, everyone, and welcome to Uncivil Law. And in today's question, we figure out whether or not it's okay to film the police station from across the street. This is the case of Turner versus Driver from 2017. In this case, a person was filming a police station from across the street. The police didn't like this. The police were sad. And so they detained and arrested this guy, and we have to figure out whether or not you can do that. Is it okay to film the police? Let's get started with this. In September of 2015, Turner videotaped the Fort Worth police station from a public sidewalk across the street from the station. He was unarmed. While videotaping, Turner observed Fort Worth police officer Grindles and Dias pull up in a patrol car in front of the station, get out, and approach him. Grindles asked Turner, "How's it going, man? Got your ID with you?" Turner continued videotaping, and Grindles repeatedly asked Turner if he had any identification. Turner asked the officers whether he was being detained, and Grindles responded that Turner was being detained for investigation, and the officers was concerned about who was walking around with a video camera. Police don't like it when you're videotaping them, I guess. Turner asked what crime he's being investigated for, and Grindles said, "I didn't say you committed a crime." Grindles elaborated, "We have the right and authority to know who's walking around our facilities. On a public street, from across the street, you have the right and ability to know who's walking around on a public street near your police complex? I don't think so." Grindles again asked Turner for identification, and Turner asked Grindles, "What happens if I don't ID myself?" Grindles responded, "We'll cross that bridge when we come to it." Grindles continued to request Turner's identification, which Turner refused to provide. Grindles and Dias then suddenly and without warning handcuffed Turner, took his video camera, and Grindles said, "This is what happened when you don't ID yourself." So the police are completely overreacting. This guy is across the street from the police station. He's videotaping the police station. Why? I don't know, nor do I really care. He's in a public place. He's videoing things that are occurring in public. There's no reasonable expectation of privacy in public. And so if he wants to stand across from a police station and video the police station, there's no reasonable expectation of privacy. He's not peering in through a window. He's in a public place using a normal video camera. If he wants to record the police station, more power to him. And the police come over and say, "Give my ID." And he says, "I don't want to." Which they don't really have a right to do that. He's not driving. He's not doing anything wrong. And then they put cuffs on him and arrest him and says, "This is what happens when you don't give ID." Lieutenant Driver approached Grindles and Dias, and they seemingly ignored Mr. Turner. The three officers then rolled down the windows of the patrol car and found Turner lying down in the back seat. Lieutenant Driver identified himself as the commander. Driver asked Turner what he was doing, and Turner explained he was taking pictures from the sidewalk across the street. Driver asked Turner for his ID, and Turner told the lieutenant he did not have to identify himself because he had not been lawfully arrested, and they chose not to provide identification. Driver responded, "You're right. Yeah, you don't have to identify yourself for no reason. The police have the right to ask questions of anybody because anyone has the right to ask questions." So the police did nothing wrong in going up to him and asking any question they want. And he can ignore them or not. It's up to him, right? Because anyone can go up to anyone else, can ask anyone else a question for any time. And he can ignore you. He can tell you to go away or anything else. A person can approach another person and talk to them. We covered this in the Captain Marvel incident. It is okay for a person to go up to someone and talk to them. If they don't want to talk to you, they don't have to. You cannot then proceed to lay hands on them. That is not a thing you can do. Either if you are the police or Captain Marvel or any of these people, no. You can't do that. So that was a bridge too far. Driver walked away and talked with the officers, then returned to the patrol car and talked to Turner. Turner said, "You guys need to let me go because I haven't done anything wrong." Driver again walked away from the car, talked on the phone, and spoke further with the officers. They then returned to the car and took Turner out of the back seat. Driver lectured Turner about what I don't know, and the officers finally released him and returned to the camera. I think I'm going to go to the Austin police station because it's very near where I live, and I'm just going to take some pictures of it for no particular reason. That sounds like the thing I'm going to do with my afternoon today. Why not? Sounds like fun. So yeah, maybe I will appear in a court case very soon. Yeah, uncivil law versus the state of Texas. Maybe that'll be a thing. That'll be fun. We review a district court's grant of a motion to dismiss based on qualified immunity from the start. We accept all well-pled facts as true and view them in the light most favorable to the person who is not moving. To survive a motion to dismiss, a complaint must state sufficient facts accepted as true to state a claim that is at least plausible on its face. To state a claim under 1983, a plaintiff must show a violation of the Constitution or federal law and show the violation was committed by someone acting under the color of state law. The doctrine of qualified immunity, which we're well familiar with on this channel, protects the governments from civil liability when their actions could reasonably have been believed to have been legal. When a defendant raises a qualified immunity defense, The plaintiff has the burden of demonstrating the inapplicability of the defense. To meet the burden, the plaintiff must show the official violated a statutory or constitutional right, and the right was clearly established at the time of the conduct. Like a district court, we have discretion to decide which prong of the qualified immunity to address. For a right to be clearly established, the contours of that right must be sufficiently clear that a reasonable official would understand what he's doing violates the right. Thus, the right must be clearly established at the time of the conduct. When considering whether a defendant is entitled to qualified immunity, the court must ask whether the law is so clearly and unambiguously prohibited his conduct that every reasonable official would understand and know what he's doing is violating the law. Yeah, so we know the qualified immunity law all too well here on the channel. Yes, it has to be a constitutional violation. It has to be clearly established. It has to be so clearly established that every official knows the law and basically is without excuse. So ignorance of the law is a thing if you're the police under qualified immunity. I'm not here to defend it because I don't really believe in it. I'm just telling you what it is. That's the law. So yeah, we have to find that this is clearly established, that you knew better, and every officer knew better. So at the time in question, neither the Supreme Court nor this court had determined whether the First Amendment protection extends to recording or filming of the police. So we're not sure whether or not that's a thing somehow. Although Turner insists, and some district courts and this circuit have concluded, the First Amendment protection extends to video recording of the police in light of the general First Amendment principle. The Supreme Court has repeatedly instructed courts not to define the law to a high to level of generality. So yeah, like Turner says, there's a right to film in general, and the court here says, and unfortunately they're correct, that that's pretty general. We need something more specific. So again, qualified immunity doctrine comes to the rescue, at least if you're the police. Good. The district court states that circuit courts are split as to whether or not there's a clearly established First Amendment right to record the public activities of police. The circuit courts, however, are not split on whether the right exists. The First and 11th Circuits have held the First Amendment protects the rights of individuals to videotape officers from doing their duties. So the government says the circuits are split on whether or not you can film the police, and this court says no, they're not. All the circuits agree. There's a right to film in general, which also includes the right to film the police in general. There might be more specific exceptions, but in general, yeah, the circuits do not disagree. They all say that there's a right. So, there's that. No circuit has held the First Amendment protection does not extend to video recording of police activity, although several sister circuits have explained whether law is not clearly established while refraining from determining whether there's a right to record the police. So they're all not quite sure on this, although at this point, so many circuits have decided it probably is clearly established. So at the time this decision was written, which I think might have been 2017, I have to double check the date. But in 2017, yeah, maybe it's not clearly established. But at this point, it's so well established in so many circuits, it probably is clearly established at this point that you have a right to film the police. So yeah, this case would come out differently, decide today, if there was a circuit somewhere trying to decide it because it's been so clearly established by the many, many circuits. But at this point in history, I guess not. We cannot say, however, that the existing precedent, again, at the time this was decided, placed the constitutional question beyond debate when Turner recorded the police station. Today, this would probably come out differently. At the time this was decided, this was probably legally correct. Today, it probably would not be legally correct, but, the law has moved since then. Neither does it seem so clearly and unambiguously that every reasonable officer would understand what they're doing is violating the law. So yeah, again, as more and more courts have decided this has become pretty well established. So if a court were writing this today, I'd be much more suspect. But 3 years ago, I don't know. 3 years ago, this probably was correct. The law has moved quite a bit in the last 3 years and is particularly well developed in the immediate situation because of the ongoing situation with the ability to document what the police are doing. So, if someone were trying to restrict this today, it would come out differently. Although the right may not have been clearly established at the time of the activities in question, whether such a right exists and is protected by the First Amendment presents a separate question. So whether it existed, and whether it exists are different questions. Because this issue arises in a qualified immunity context, we now proceed to determine it for the future. We conclude, so this is now binding authority, at least in the Fifth Circuit in Texas, we conclude the First Amendment principles, controlling authority, and persuasive precedent demonstrate a First Amendment right to record the police does exist, subject only to reasonable time, place, manner restrictions. So There was a separate question of did it exist versus does it exist. So did it exist at the time? No, probably correct. But the Fifth Circuit then goes to the next logical step. Does it exist? And the courts don't always answer that question. Sometimes they don't answer that question, which I find really, really annoying, because it's like you should establish it one way or the other for the future. And here the Fifth Circuit does reach the next logical question. Does it exist going forward? And the answer is yes. So generally speaking, yes, you have a right to film the police in general. And it can be subject to time, place, manner restrictions. Well, what might those restrictions include? Well, for example, it would allow the police the ability to tell you to back away if you're trying to get your camera right up into an arrest in progress. So if you saw an arrest in progress and you decide what I'm going to do is going to run right up in there and try to film it, the police can lawfully ask you to back away. They can ask you to back away from a distance as part of a police operation. So, they can't restrict. So that would be an example of a time, place, manner restriction. As it's going on right up in the officer's face, no, not so much. Not without their permission. So if you're the show cops, then yeah, you have permission. If not, then they can exclude you. That's fine. So, can they make you film from across the street? Yeah, probably. That sounds fine. Can they make you do certain times a day? Maybe. Depends why. So we're under an intermediate scrutiny analysis. You'd have to have a substantial governmental interest, and it would have to be tailored to that interest. So, not just any reason will do, it has to be a substantial reason. And not just any restriction, it has to be one that is tailored and governed by the situation. So, can the police make you go up a block away when they're like raiding a store? Yeah, that sounds like a thing they can do. Can they make you record from across the street? Yeah, that makes it a thing they can do. But can they prevent you from interfering in police operations? That's definitely a thing they can do. But if you're like a block away, or you're across the block and you're just recording across the street, and there's not like an ongoing police operation, you're not interfering with their ability to conduct whatever operation, then the police have to leave you alone. So in general, yeah, you can record the police as long as it doesn't interfere with their operations. Yeah, and you can probably figure what that is on your own. You probably don't need me to tell you what it means to interfere with police operations. You're supposed to be an observer, not a participant, right? That's what journalists do. They observe, they don't participate. And we could argue about the degree to which journalists are doing that these days, being observers, not participants. But yeah, be an observer, not a participant. Cover the story, don't be part of the story. There's your guidelines for the day. How about that? In addition to the First Amendment's protection of a broader right to film, the police underlying the First Amendment support of this particular right to film the police. There is a practically universal agreement that major purpose of the First Amendment is to protect free discussion of the government affairs. So, yes, you have a right to film in general, and even a more specific right when it comes to the police, because documenting the police is kind of one of the essential purposes of the First Amendment, figuring out what the government is doing. So you have a heightened interest, not just a normal interest, a heightened interest. As one court has explained, gathering information about government officials in a form that can be readily disseminated to others serves a cardinal purpose in the First Amendment interest in protecting and promoting the free discussion of governmental affairs. Moreover, as the Supreme Court has noted, freedom of expression has particular significance with respect to the government because it is here that the state has a special incentive to repress oppression and often wields a more effective power of suppression. This is particularly true of law enforcement, who are granted substantial discretion that may be misused to deprive people of their rights. Ensuring the public's right to gather information about their officials not only aids in the uncovering of abuse, but also may have a salutary effect on the functioning of government more generally. We agree with every circuit that has ruled on this question. Each has concluded the First Amendment protects the right to record the police. As the First Circuit explained, the filming of government officials engaged in their duties in a public place, including police officers performing their responsibilities, fits comfortably within basic First Amendment principles. The right, however, is not without limitation. Like all speech, filming the police may be subject to reasonable time, place, and manner restrictions. In this case, however, we need not decide which specific time, place, and manner restrictions would be reasonable. So, yeah, you would have to go through a First Amendment analysis, but we don't have to describe that because, again, it might be a little bit fact-specific. But we have a general idea what we're talking about, right? Ongoing police interruption and a situation don't interfere with the operation. That would be a classic example. So having considered the First Amendment question about the right to film, we now have to consider the Fourth Amendment question because this person was seized. They were detained as part of their initial questioning, and they were also arrested, thrown in handcuffs and thrown in a car. So we have to consider the Fourth Amendment issues. Was this guy's Fourth Amendment rights violated, in addition to First Amendment rights? Let's read on. Turner alleges that Grindle and Dias' initial questioning of him violated his Fourth Amendment right to be free from detention, absent reasonable suspicion. The police can stop and briefly detain a person for investigative purposes if an officer has reasonable suspicion supported by particular facts that they may be afoot. The Fourth Amendment is concerned with ensuring the scope of a given detention is reasonable under the totality of the circumstances. Turner alleges that when Grindle and Dias approached him, he was videotaping the police station while walking on the sidewalk across from the street during the middle of the day. Nothing in the amended complaint suggests that Turner was videotaping an arrest, traffic stop, or any other action or activity performed by the police in the course of duties. On the contrary, he states only that he was filming routine actions of the police department building. What is not suspicious in one location may be highly suspicious in another. Turner's filming of the front police station potentially threatened security procedures at a location where order is paramount. An objectively reasonable person in this position could have suspected that Turner was casing the station for an attack, stalking an officer, or otherwise preparing for criminal activity, and thus could have found the filming of routine activities sufficiently suspicious to warrant questioning and a brief detention. The officer's detention of these under circumstances was not plainly incompetent or a knowing violation. We cannot say, when viewed in light of the totality of the circumstances, the initial questioning of detention before they are being handcuffed was objectively unreasonable. All right, so far we have split this into two parts. We've got the detention and we've got the arrest. So we got the initial approach, initial detention, and the arrest. So the arrest occurred when he was thrown in handcuffs and thrown in the back of the car. We got the initial detention. Now, let me say that it's not clear to me he was being detained. The officers seemed to suggest that he was, and they seemed to stop him, but at the one time, like, he was engaging in the behavior he was engaging in already, which was filming. So, like, he's walking across the street and the police say, "Can I ask you a couple questions?" Is that really detention? I don't know if that really qualifies as detention. But let's assume it does for the purposes of this example, right? And that he's not free to leave. So were the police detaining him? Not 100% clear from the facts. They say that he was walking down the street, so was he walking or standing is a little unclear on the facts. If he was standing, probably not. And so they asked some initial questions. So they're doing an initial stop to ask what's going on. So could they ask a couple questions? Yeah, maybe. But now we have to turn, so maybe that part, they can ask. And again, anyone can walk up to anyone else at any time and ask them questions. So, like, if a normal person can do this, a police can kind of do it. So was this legally a detention? I'm not sure. Not 100% sure I agree with the court on that one. But when he was thrown in the back of the car with handcuffs, that was definitely an arrest. So I'll agree with the court. I'm not sure I agree with the detention, but I'll agree with them that that was an arrest. So let's turn to whether or not the arrest was proper. Turner also contends the officers violated his Fourth Amendment right to be free from an unlawful arrest. The parties dispute whether detention amounts to an arrest. Okay, so when is an arrest apply? A seizure rises to the level of an arrest only if a reasonable person in the position would have understood the situation to constitute a restraint of freedom of movement of the degree of which the law constitutes a formal arrest. Well, being handcuffed and thrown in the back of a car qualifies to remain. When determining whether an investigative stop amounts to an arrest, the relevant inquiry is always one of reasonableness under the circumstances, which must be considered on a case-by-case basis. Using some force on a suspect, pointing a weapon at a suspect, ordering the suspect to lie to the ground, and handcuffing a suspect, whether singularly or in combination, does not automatically convert an investigative detention into an arrest. But an investigative detention must be temporary and last no longer than necessary to effectuate the stop. So the court is here saying that handcuffs don't mean per se that it makes it an arrest. All right, I'm not 100% sure I agree with the court on that one either. You know, handcuffs seems like the kind of thing where you're very clearly not free to leave and very clearly being detained. So it's like, you know, for me, handcuffs, is it per se? I don't know about that, but under these circumstances, I would say that qualifies as an arrest. The Fourth Amendment right to be free from arrest without probable cause was clearly established at the time of the alleged arrest. None of the defendants contend that they had probable cause to arrest, or arrest would have been objectively reasonable in the light of clearly established law. We're satisfied no objectively reasonable person in these officers' positions could have believed there was probable cause to arrest under the circumstances alleged. Gildas and Dyson are therefore not entitled to qualified immunity at that stage of litigation on the Fourth Amendment claim because of the right to be free from probable cause. Yeah, so I agree with the court here that he was under arrest. At the time he was handcuffed and thrown into the back of the car, that's got to be an arrest. And so the question is, you need probable cause. So Was he legally being detained? Was that a Terry stop when he was initially being questioned? I don't know if that was a detention or not. I don't know if that qualifies. It seems not quite sure. But when he was handcuffed and thrown in the back of the car, I agree with the court. That's an arrest. And you need probable cause. So did the officers have initial right to go up and ask him questions? Yeah, sure, probably did. Did he have a right to refuse? Yes. But the moment they handcuffed him and threw him in the back of the car, that was an arrest. And you need probable cause. Probable cause of a crime. What crime? There is no objectively reasonable basis under which to say there was a crime here. So yeah, they violate his Fourth Amendment rights. So they may not violate his First Amendment rights to prevent him from filming, but they definitely violate his Fourth Amendment rights when they arrest him because they arrest him without probable cause. And so that goes forward. So that claim can be heard. Turner insists that Driver, the lieutenant, violated his Fourth Amendment rights by continuing the unlawful seizure and subsequent handcuffing, by keeping him locked up. Supervisory officials are not liable under 1983 for acts of their subordinates. So yes, we remember this very well. We need a Mundell claim. We need to look to something Driver himself specifically did if we want to hold Driver responsible. We affirm the district court's grant of qualified immunity to Grindle, Driver, and Dias on the First Amendment claim and on the Fourth Amendment claim for respect of unlawful detention. With respect to the Fourth Amendment claim for unlawful arrest, we affirm the district court's grant of qualified immunity as to Driver, the lieutenant, because he didn't do enough to find him liable. But we reverse this to Grindle and Dias and remand for further proceedings. So that is the end of the case of Turner versus Driver. In this case, we learned that Turner was arrested for violation of doing nothing in particular. And the cops, the First Amendment right wasn't clearly established. Was he legally detained? But he was definitely arrested. And so that Driver himself didn't do anything. So we can't get to Turner because there's no respondeat superior liability in 1983. You need to find individual responsibility. So you need to find something Driver did, or you need to find either Driver himself did to find a 1983 violation, or you need to find that he conducted training and supervision for a Mundell claim, one of those two things. But either way, no, you can't get Driver for the arrest, but you can definitely get the other officers for their arrest because they improperly arrested. So there is a right to film the police, generally speaking, don't interfere with the police. They can scoot you to a distance to prevent them from interfering, and they can't arrest you for just filming things at large. So, at least for the moment, that's the end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. If you liked this latest video, please give it a like below and hit the join button. For 99 cents a month, you too can give a recurring membership that helps this channel grow and helps YouTube to recommend this channel to others. We really appreciate your continued financial support and all your love. And until later, my friends, cheers and goodbye.